So what if there is no estate plan in place? I used to do a quarterly seminar to teachers unions around the Twin Cities prior to COVID with a financial planner who would always start the seminar by asking who had an estate plan in place already. And a few people would raise their hands, and then he'd look around, kind of pretend to count who had their hand raised. And then he'd say, oh, those of you who don't have your hands raised, you're wrong. You do have an estate plan. And the state of Minnesota wrote it for you. And it was kind of this fear tactic-y thing of leading into what we call intestacy statutes. And what intestacy statutes are laws that come into place when someone dies intestate. And all intestate means is that they died without a will or without a plan in place. And when someone dies without beneficiaries, without a will, without a plan in place that says where assets are supposed to go, the state's left going, well, what are we supposed to do? And so they have laws in place that they can look to. And if someone passes away without planning, there's a likelihood there's going to be probate court. And probate court is a specialty type of court that exists to pass assets after someone dies. Now, if you have a will, wills still get probated, assuming the estate requires it. And now this is where it's different in every state. What will require or trigger probate court varies state to state. In Minnesota, what triggers or requires probate court is if the person who passed away owned real property, so a house, land, etc., and it's not passing by joint ownership or trust. Basically, there was nothing in place where it's going to pass automatically. And or if the person who passed away has assets that add up to more than $75,000 that aren't passing by beneficiary designation. So I'll give an example. Say someone passes away and they have a house, but their spouse is a joint owner as a joint tenant. They have retirement accounts that all have beneficiaries. They have life insurance that has beneficiaries. And then they have a checking account with $20,000 in it and a savings account with $70,000 in it. Now the house is going to go to the spouse because the spouse is a joint tenant owner. The retirement and the life insurance, that'll go by beneficiary. This is all great so far. We're avoiding probate. But the bank accounts, they add up to more than $75,000. Those could require probate. And you kind of get the gist. It gets very fact specific. And a lot of clients that come in, their goal is to avoid probate. And one thing we're looking at is what their estate looks like. How are your assets held? Where do you have your savings? Where do you have your investments? What is the approximate dollar amount? What is the approximate value? That empowers us or enables us to identify the most efficient and cost-effective method to avoiding probate. In that hypothetical I just gave, well, if there's a bank account or bank accounts that don't have joint owners and you want to avoid probate, well, maybe it's just a matter of doing payable on death designations with those bank accounts. A favorite lawyer response to questions is, it depends. And in this situation, it would depend on how are the assets structured, where do we want them to go, how is this set up?